Move to the final case on today's docket, Smith versus the state of Florida.
Good morning.
Good morning.
May it please the court? My name is Karen Moore, and Elizabeth Spiaggi and I represent Terry Smith in this appeal of the denial of his post-conviction guilt phase claims out of Duval County, Florida. We're asking this court to reverse the circuit court's ruling on the guilt phase claims and remand Mr. Smith's case for a new trial based upon the sheer number and severity of errors by trial counsel that renders Mr. Smith's trial unreliable under Strickland. Trial counsel, Mr. Kurtz, was appointed to represent Mr. Smith on November 30th, 2009. He neglected to get an investigator appointed until March of 2010. He forgot to get second chair appointed until August of 2010 when this capital murder case was less than 2 months out from trial. He billed 2,300 hours in other appointed cases during the time that he represented Mr. Smith, and he testified that his private cases were more than half of his caseload. In the few months before Mr. Smith's trial, he tried 4 murder cases, including 2 capital murder cases, while he was representing Mr. Smith, and a second-degree murder case less than 2 weeks before Mr. Smith's trial. He resolved numerous other capital cases during the pendency of his representation of Mr. Smith. As a result, he was not properly prepared for trial and made objectively unreasonable strategy calls. Probably the most egregious is that Mr. Kurtz offered testimony, or offered portions of videotaped interrogation of Mr. Smith where the detectives accused him at least 26 times by my count of lacking remorse. And I'd like to give the sample of some of the things that counsel offered. Detective Nelson, you better find somewhere in your heart to find some type of remorse, because if not, the only thing that they can portray of you is that you're a guy who cold-bloodedly killed 3 people. Detective Nelson, can you please show some remorse for the people you killed? Detective Chiswick.
Am I correct that the defense was that the defendant was not there and did not commit the murder?
Yes, sir.
Okay. And the testimony of counsel at the evidentiary hearing was that he made a specific decision, a strategy decision to play these portions that you're talking about, because the detective, he had a lot of experience in cross-examining this detective. The detective came off as very kind, very nice, very thorough, very polite to a jury, and these portions, according to counsel, showed him in a very different light, showed him as badgering, bullying, aggressive, and as violating the defendant's constitutional rights by not ending the interrogation when the defendant said that he wanted to end the interrogation. Now that the trial court credited that and determined it to be reasonable strategy. So the issue for us is, why is the trial court's ruling wrong?
Well,
because and let me just add to that it is a long question, I apologize, but it seems like telling him he's showing no remorse would not be prejudicial if there was a defense that it wasn't even him that was doing it. I mean, it seems like it would show the detective as being in a bullying, badgering position.
Let me try and answer your
Okay.
question.
Sorry.
Mr. Kurtz, 3 days before the jury selection at the last pretrial conference in this case, told the trial court, look, I've been reviewing this interrogation, and I'm thinking about filing a motion in limine on this. I don't even see where there's any relevance. All the police are doing is accusing him of being guilty, and he's denying. The state recognized at that same hearing that the interrogations yielded very little relevant evidence, and I would say the only relevant evidence was that Mr. Smith denied being in the home or knowing anything about the murders. Mr. Kurtz could have simply confronted Detective Nelson with the number of times that Terry Smith asked to be returned to his cell. There was a written transcript of these interrogations.
And
impeached him.
what did he testify to as to his reason for actually playing the tape instead of confronting him in cross-examination with what he did in the interrogation?
Well, his explanation was that he wanted to show the bad conduct of the officer, but when I confronted him with, well, you offered 26 examples of their lack of remorse, you offered a number of accusations by the detectives that, or the detective's theory of opinions of his guilt, and he said, well, I thought I filed a motion in limine on that. I thought I moved to exclude that. The trial court's findings that it was reasonable are belied by what Mr. Kurtz said. He said, I thought I filed a motion in limine on this. And because of the egregious nature of this evidence, lack of remorse can be reversible error. Accusations or opinions by the police officers that the defendant is guilty is reversible error if offered by the state over the defense objection. Mr. Kurtz offered damning evidence against his own client. It would have been much simpler and cleaner just to impeach him from a written transcript of the number of times that Kurtz did this, or the number of times that Detective Nelson did this. And Kurtz did try to bring that out through the Nelson's interrogation of the other witnesses in the case, so he'd already established some of that. But, I mean, a reasonable trial lawyer would weigh the danger. Okay, I can cleanly impeach him with a written transcript, or I can put before this jury 26 accusations that he lacked remorse, that he killed these people in cold blood, and our opinion, the detective's opinions, that Terry Smith was guilty. I don't find that reasonable, and I don't find the trial court's finding that it was substantial, or that it was a reasonable strategy decision based on the nature of the evidence offered by counsel and his own statement. I thought I filed a motion in limine on that. So that's very disturbing. Another statement, I mean, opinions of guilt and accusations of lying. What did that unarmed young woman do to cause you to take her life, other than seeing you take somebody else's life? That was the only thing that she was guilty of, standing there watching you take somebody else's life. The next best thing for you, you took hers. Throughout the interrogation, which is an agonizing thing to watch, these two detectives are standing over Mr. Smith, and he's slouched, and he's mumbling, and he's cursing, and there was not a sympathetic portrayal of Mr. Smith at all, and I think it was just really bad strategy, and I don't know any other lawyer would have done that. There would have been a clean way to do it, and they didn't do that. Not only did counsel offer damning evidence, outrageous evidence against his client, he stipulated 2 mugshots. Mugshots are inadmissible. This was not an eyewitness identification case. This was not a case where the defendant was in jail and the jury would necessarily know that he was an inmate. The mugshot shown to Breon Williams, clearly visible, inmate, Department of Corrections. 2 other mugshots entered through 2 other witnesses. These went back to the jury. The jury could have easily inferred that Mr. Smith had been arrested or convicted for 3 crimes prior to this. I mean, it should have been objected to. Failing to investigate your case and failing to research the law applicable to the facts is quintessential ineffective assistance of counsel. Mr. Kurtz failed to challenge the forensic
Do you have a
evidence.
claim of ineffective assistance counsel for failure to properly investigate? Which claim is that?
It's throughout. I pled it throughout that he failed to properly investigate the evidence in the case, the forensic evidence, failed to challenge do the rudimentary research on some of these hearsay and inflammatory evidence issues. It's throughout my.
Okay.
Yes, sir. He stipulated 2 written statements on the mugshots that went back to the jury. He failed to challenge.
Had the person who had written this statement on the exhibit already testified? Williams, hadn't he already testified that he had witnessed Smith shoot Robinson?
Yes, he did. He did. And
So
then
this came in after the fact. It was already.
Mr. Williams testified to what he saw, and he recounted the admissions Smith allegedly made to him, and then the mugshot.
But then the written.
Then the written statement.
The written statement on the photo came in, so it's just duplicative of what he's, in a way, to what he's already testified to.
But it bolsters, too, because throughout this case, the state was worried about the credibility of their witnesses. They all had felony convictions, with the exception of Ulysses Johnson. The state painted them as not angels. So it was bolstering, okay? It was bolstering that witness's testimony. He's already testified to it. Now he's shown the mugshot with the written statement on it, and he reads it verbatim, and then it goes back to the jury for them to read and read and read. It's hearsay. It's an out-of-court statement offered for its truth to bolster that witness's testimony and the witnesses before and after him. And they did it with each. So it shouldn't have come in. And again, it's a failure to do basic research. The defense also failed to challenge the forensic evidence in the case. The night before the trial, after jury selection at 8:10 p.m., Mr. Kurtz sent an email to his co-counsel, who was primarily responsible for the penalty phase, and handed off 4 witnesses. Said, "I'm tired. Would you please take, FDLE examiner Shad, who did the DNA evidence, FDLE firearms analyst Warnament, Mr. Nixon down the street, and Dr. Giles, the medical examiner. Pay attention so I don't have to, and there aren't many questions, if any." And then Mr. Kurtz wrote Mr. Hernandez that the casings found in the house were all from the same gun. That wasn't correct. No attachment of suggested cross questions, said little to no questions for any of these. Defense counsel, Mr. Hernandez, did not cross-examine Dr. Giles, asked about touch DNA with Ms. Shad, did not challenge Warnament's testimony as to where the casings were found in the house or if they were ever test fired. There was live ammo found in the back bedroom that could have been test fired in the gun taken from Mr. Gibson's hand. That never happened. It wasn't challenged at all. And there's really great prejudice here. The trial court found and used as an aggravator, no, we're not here on that, but the trial court found and the state argued that after Smith killed Mr. Robinson in the front of the house, he stepped over his body and walked to the opposite end of the house and executed Berthum Gibson and Keenethia Keenan. Any cursory review of the crime scene photos would lead counsel to hire help for this. This was a small house, concrete block house, the whole way straight down into the bedroom where Berthum Gibson was found, right in the doorway, leaning up against the bed with an AK-47 in his hands. There was live AK-47 ammo on the bed, full metal jacket, some soft core. Ms. Keenan was found in the left corner of the bedroom, according to Detective Kicklighter, who did part of the crime scene investigation. She shot once. No projectile is ever found in that room from a 10 millimeter. There are AK-47 shell casings by her hip and leg from Full Metal Jacket that indicate, certainly could have been argued, that Berthum Gibson shot Ms. Keenan.
Let me ask you about the post-conviction experts.
Yes, sir.
Did any of them testify that the state's theory of the case was inconsistent with the crime scene evidence?
Yes, sir. Both did. Dr. Paneri and Mr. Robinson, they both said that the evidence that they viewed was consistent with Mr. Gibson shooting Ms. Keenan. Now, on on cross-examination, they didn't rule out the possibility.
Well, that was my question to you, though. My
They didn't rule out
question
that
was, did
possibility.
they say that the evidence was inconsistent with the state's theory of the case?
I'm sorry. Well, it could have been either way. That was the point. They couldn't rule out either. And which would lead reasonable counsel, to argue reasonable doubt, case not proved. The state hasn't proved what happened here. And if you look at the bullet damage in that house, Your Honor, AK-47, the person with the rifle was backing down the hallway, shot through a wall, Full Metal Jacket round goes through the wall and through the refrigerator and comes out intact. Rifle shot goes, as he's backing up, rifle shot goes through the cement, the drywall and the cement cinder block wall. Doesn't come out the other side. I mean, these Full Metal Jacket, which our experts described, can cause the same type of injury that a 10 millimeter round would. Because they're Full Metal Jacket, they don't lose velocity, they're not soft, they don't break apart, they don't start to yaw or wobble until they've gone through the body, and it's very easy to mistake at an autopsy what a 10 millimeter round can do versus a Full Metal Jacket AK-47. This was never investigated by anybody. And these witnesses were handed off at the last minute by Mr. Kurtz to Mr. Hernandez. Mr. Kurtz's explanations, too, need to be closely looked at. When I asked Mr. Kurtz
Counsel,
why...
I want to let you know, you are in your rebuttal time, so you can keep going, but you're consuming time.
Your Honor, significant prejudice caused by the failure of counsel to prepare for trial and to present a cogent defense, putting on this evidence that client lacked remorse and opinions by the detectives that he was guilty was outrageous. The forensic evidence should have been investigated, and counsel did not advance Mr. Smith's version of the events. I know the deference is due to trial counsel, but the trial court failed to...
Well, you said counsel didn't advance Mr. Smith's version of events. Didn't counsel testify that Mr. Smith told him at the time of trial that it happened exactly the way the state's evidence said that it happened?
After Mr. Kurtz read the Florida
So
Supreme
you're
Court-
talking about his post-conviction testimony?
Yes, sir.
Okay.
Yes, I am. Here's the problem with Mr. Kurtz's giving deference to trial counsel here. Failed to weigh Kurtz's testimony against co-counsel. Mr. Hernandez said that he would not have offered the interrogation information, that he would have challenged everything that he could in the crime scene and the ballistics, and that he wasn't an expert. We put on the testimony of Michael Hurst, their fact investigator. Mr. Kurtz said that Mr. Hurst is a gun guy, he worked Nassau County Sheriff's Office, he knows everything, he went over all the evidence. Mr. Hurst said, no, that didn't happen. I never reviewed the evidence with Mr. Kurtz. And by the way, I don't know anything about that. We would call an FDLE when we had serious crime scenes. Mr. Kurtz contradicted himself in his own testimony. First, he didn't investigate the forensic evidence because he didn't need to. Then he didn't investigate the forensic evidence because Mr. Hurst told him all about it. Then he didn't investigate the forensic evidence because Mr. Smith admitted to him. But Mr. Smith, according to his testimony, admitted days, maybe as long as 2 weeks, right after the second-degree murder trial. What was Mr. Kurtz doing for the 15 months before that to investigate all this evidence? It doesn't absolve him of that, but Mr. Kurtz has made inconsistent statements, and the trial court's reliance is just not founded. And this court's not bound. I mean, I know you hew substantial competent evidence, but it's got to be reasonable findings. And in Dorsey, this court reversed the trial court's finding that was due great deference on the state's stated race-neutral reason for striking a witness and said, or a juror, and said, it's not blind deference and it's not blind allegiance. We can't abandon our duty to review these cases. So I would ask the court to allow me a few more seconds in rebuttal. Thank you.
You have used almost all your time. I will afford you 1 minute for rebuttal.
Thank you, sir.
Good morning. May it please the court. My name is Lisa Hopkins. I represent the state in this matter. We are here for the triple homicide of Desmond Robinson, Keenethia Keenan, and Berthum Gibson. At the evidentiary hearing, Mr. Kurtz testified. My client admitted to me what happened. He admitted he was the shooter. He also testified that one of the witnesses, Edward Haney, who issue was a recantation, before trial admitted Mr. Haney's statements at deposition to police are true. Now, I'd like to start with the video of Mr. Smith and Mr. Kurtz's strategy in admitting that video. A cold record is very different from a video and a tape. Mr. Kurtz testified that he wanted to show the jury the coercive tactics of Detective Nelson, and he did so with the video of Mr. Smith and as well as with Breon Williams. He highlighted multiple times during his closing argument, during cross-examination, showing that Detective Nelson repeatedly ignored requests to end the interrogations. It showed Detective Nelson as aggressive. It showed him as confronting these witnesses. It went towards the credibility of each of these witnesses, suggesting that Detective Nelson fed them the information about what happened the night of the triple homicide, and his strategy was to show the jury what Detective Nelson was actually engaging in. Now, the mugshots. During trial, these photos were never identified as mugshots. They were never identified as booking photos. There was the one photo with Breon Williams that Jacksonville Sheriff's Office insignia was noticeable. However, with the other two, it was not. Additionally, as was pointed out, the statements, the witnesses for each of these photos had already testified to what happened. The post-conviction court, Judge Soud, who was also the trial judge in this case, ruled that the overall use of these statements was ultimately not prejudicial to Mr. Smith, given that the witnesses were available for cross-examination. Their statements, Mr. Kurtz actually brought out that all of these witnesses initially denied knowing anything about the case, denied any involvement, and again, all pointing out to the tactics of the detectives, insinuating that these witnesses had made up their statements to comply with whatever the detectives wanted them to say. And ultimately, these statements were used as prior consistent statements. In the case of Mr. Peterson, he had made his statement 6 months prior to engaging in a plea deal that was brought to that was put before the jury to suggest that he had a bias to testify the way the state wanted him to in order to get a better sentence from the state for his pending cases. Now, regarding the forensic evidence, each of the experts called at the evidentiary hearing testified that the state's theory was not wrong with what the evidence showed. They may have had a different theory of what the evidence showed, but ultimately also concluded that, even in the case of Mr. Robinson, who, when asked if the state's theory was consistent with what the evidence showed, he responded, absolutely. These forensic witnesses would have merely served as an alternative theory, which Mr. Kurtz testified his strategy was to point to it was someone else. That the Raylan Johnson and Ulysses and Raylan Johnson were brothers. They suggesting that they were trying to put it on Mr. Smith to protect each other. That in this case, it was undisputed that the victims all died from gunshot wounds. It was all the same series of events in which Mr. Robinson was killed first, and then the other two victims were killed in the back bedroom. In regarding to the Smith's version of events, on direct appeal, it was argued that this was actually self-defense. And then at the evidentiary hearing, Mr. Smith now claims it was a light brown-skinned male with dreadlocks who is actually the one who committed this murder. And I didn't say anything at first because I didn't know who he was and I didn't want to be a snitch. These are wholly inconsistent versions of events, and Mr. Kurtz is under no obligation to present a theory of defense, a theory of versions that he does not agree with, especially given in light of the defendant's admission to committing these three murders. There should be deference given to Judge Soud, again, as he was the trial judge and both the post-conviction court judge. He is able to observe the demeanor of each of the witnesses. He's able to he heard all of the evidence at the trial as well as at the evidentiary hearing, and he relied on the testimony of Mr. Kurtz. That is competent, substantial evidence, and deference should be given to the trial court's order. If there are no questions, the state is asking that you affirm the denial of the guilt phase claims and deny the habeas petition. Thank you.
First, do no harm. Counsel offered inflammatory, outrageous evidence against his own client that created substantial prejudice that would have been reversible error had the state offered it over defense counsel's objection. Mr. Kurtz's obligation to Mr. Smith was to hold the state to its burden of proof, especially as he claims, since the client admitted to him. Under chronic, what he must do at that point is test the state's case. Instead, he stipulated 96 items of evidence, offered terrible evidence against his client, stipulated to mugshots. This was not the adversarial process envisioned under Strickland, and Mr. Smith should be granted a new trial. Thank you.
We thank you both for your arguments, and the court is now adjourned for the day.
All rise.